My name is Thomas Bona. I'm a partner in Pillinger Miller Tarallo, and I'd like to welcome you to Pillinger Miller Tarallo's podcast, Risk Matters. Risk Matters examines thought-provoking insurance and risk management topics by interviewing leaders in the insurance industry. Our guests today are PMT partners Scott Miller and Ken Krajewski, who will be talking about construction defect and complex litigation. Scott Miller is the managing partner of Pillinger Miller Tarallo's New York office, and he's the head of the construction defect and complex litigation practice area. He has been involved in construction defect litigation for over 30 years and has defended some of the most serious and complex cases in New York. Ken Krajewski is a partner in our Buffalo office. Ken also devotes a substantial amount of his time and his practice to construction defect and complex litigation. Ken is well known in the Western New York area and has also litigated some of upstate New York's most complicated and serious cases. So let's dig in. Welcome, Ken. Welcome, Scott. Let's talk about.
Thank you, Tom.
Yes, thanks. Let's talk about construction defect. Let me start with you, Scott. What exactly is construction defect litigation, and why is it important?
Well, it's a very important type of litigation in New York City because as you just look around, you can see construction is happening all the time. And it's not just construction of smaller buildings, it's construction of very large luxury buildings. Those buildings have to be built, of course, to spec and have to be built in such a manner that they are designed and function as intended. Construction defect happens when the design or the construction or the installation or the actual individual products that are used within the installation or construction are defective in some way, and the building does not function as it should. It has leaks or it has some type of issue with the walls that are built. They could be not holding up the way they should because of epoxy, because of different types of issues that arise when construction and or design are defective.
Good. Thank you. That's a very comprehensive and a good place to start. So Ken, let me ask you this. I've heard a couple of terms in construction defect. What's a design defect and what's a means and methods defect? Can you tell us a little about what that means and how that fits into construction defect litigation?
Sure, Tom. As Scott said, there are a number of different ways that a defect can arise relative to a building's construction. At least two of them can be the design or the means and methods of doing the construction. Now, the design is quite simply, did the engineers and architects design a building or a product, so to speak, because that's what it is to them, within proper specifications, within the applicable industry standards, within the building code, things like that, within generally accepted architectural or engineering practices. Those are all very important aspects to the basic design of the building. But then there's also the aspect of the means and methods. Did the contractors, whether it's the general contractor or any subcontractors or prime contractors, did they build what the plans and specifications required them to build? As you can imagine, as anybody who's done any kind of construction can imagine, sometimes the plans or the specifications don't quite match what is happening in the real world. And, there are methods for contractors to deal with it. but there are also opportunities for contractors to try to gloss over it and hope that it'll just work out. And that can be a type of defect as well.
That's a great answer, and I thank you for that. Very enlightening. Let me go back to Scott for a second. Now, Scott, you've mentioned some of the types of these accidents that can arise construction defect, and typically these are large accidents. These aren't hitting the rear bumper type of car accidents. These are big, big accidents. And with big accidents, you've got a lot of evidence. You've got always an issue of spoliation and subsequent repairs. How do you make it so that you have prevent spoliation, but yet you need to do subsequent repairs in a big accident? How do you handle both of those competing things there?
Well, Tom, as you point out, these are big cases, and they are about a construction of a building that is usually either being constructed and or has been constructed. And as a result, the developer and the owner want the building to function. They want people living in the building, and they don't want to stop the repairs or corrections that need to be done to complete the building or to put the building in a functional state. So as a result, when a lawsuit is brought or you believe that a claim is going to be brought, you must, to prevent spoliation, which is the loss of evidence because of a subsequent repair or because of destruction, is to go immediately to the job site, go immediately to the building, have your expert there, make inspections early on, as soon as you know the claim is going to happen, as soon as you know that there's a lawsuit. If you do not do that, evidence is lost. Crucial evidence is lost as the litigation goes on, repairs are done. Now, if you're a developer or an owner, you have a responsibility, if you're going to do repairs, to put everyone on notice that you are going to take some kind of remedial action so that everyone can go to the site and see what is being repaired and why. And at that inspection, it's very important to bring experts to look at, to photograph, to determine from your perspective what was the cause of that particular defect or damage.
Scott, you mentioned a very important concept, and I want to ask Ken about this. Ken, have you had occasion to make, say, rapid response and go to accident sites right after they've happened in order to try and collect the evidence, preserve the evidence, so as Scott was saying, to prevent spoliation or to gain the most advantage that you can from a prompt and quick response?
Absolutely, Tom. And I just want to point out one thing. You're saying accident, and these aren't always accidents. Sometimes the design defect can be something, the building was built the way it was designed, but yet it doesn't, as Scott said, it doesn't function the way it was supposed to. So, I mean, that gets into a whole coverage situation, which is beyond the scope of where we are, but it's not always an accident. Sometimes it's not an occurrence. So we have to deal with that. But in any event, yes, I have responded to situations with immediate concerns. Sometimes it's something that can actually create problems for life and limb. I mean, if you have a building that somehow or another is collapsing, there's the example could be, of course, the condominium complex that dropped in Florida. We didn't have anything to do with that, but that's everybody is probably familiar with that. And you want to be on that site, if not the same day, with the very next day, and you need to be there, one, with your client, because your client has intimate knowledge of what happened, and two, you need to have an expert on call to be able to meet you out there and say, okay, I'm looking at this, and here's the determination I made. And the reason again is simple for this sense of urgency, and that is there might be a problem with danger to life and limb to people. If it's a residential complex, people living there, their location, their residence or whatever might not be livable anymore, and that creates some real problems for people.
You've brought up some very, very, very important points, and I want to turn back to Scott and let him follow up on some of the things that you've said. For example, you mentioned meeting with your client, you mentioned being in contact with your client. Obviously, Scott, in these kinds of situations, there are a lot of parties involved, or there can be a lot of parties involved. How important is it to, know who your client is, where they fit in, and where are they in the general pecking order in terms of the construction or the work or whatever is being done? Can you talk a little bit about that?
Sure. Of course, it's extremely important to know where your client fits in. You have construction managers, you have general contractors, you have subcontractors, then you have subcontractors of subcontractors, you have the owner, the developer, and each one has a different role. And their roles are always, especially on these large construction projects, they're always described by contract in the scope of work. And so the first thing you must do is, as soon as you are aware of a construction defect claim, you go to your client and you must secure all the contracts that client has. Now, if they're a subcontractor of a subcontractor, they only may have one contract with the electrical contractor, for example. But if they're a construction manager or a GC, a general contractor, they might hold 25, 50 contracts with subcontractors. And each one of those contracts will spell out the scope of work of the subcontractors. As far as a construction manager or a GC, their contract is usually with the owner or developer, and that contract will spell out their role as construction manager or general contractor. And once you look at the contracts, the most important, at least an extremely important part of the contract, is the indemnification clauses and the additional insured clauses, which require one of the parties, usually the party that is below in the pecking order, to indemnify the party above. Say it's the subcontractor, will have to indemnify the construction manager for any acts or omissions that arise out of their work. Now, that language is not the language that is in all contracts, but it's something similar usually. And it also requires the subcontractor usually to obtain additional insured coverage for everyone above them in the pecking order. So that aspect is extremely important to move on quickly. If you have a contract that requires a subcontractor to indemnify you, you must immediately put that subcontractor on notice of the claim and put their insurer on notice of the claim, so that the risk of the actual lawsuit and the damages will be transferred to that subcontractor and or their insurer.
You've given us a lot to unpack there, Scott. So I want to turn back to Ken and ask him a question about that very topic.
Sure.
Ken, it sounds like when you're involved in a construction defect claim, one of the main things that you will be looking for is risk transfer. Is that fair to say and accurate?
That's absolutely fair to say, and extremely accurate. And as Scott said, it's incredibly important to get that weeded out right up front as soon as you possibly can. Keep in mind that most insurance policies require prompt notice. And if you haven't given prompt notice, For example, if, as Scott says, you're the general contractor and you're named as an additional insured on a subcontractor's policy, you want to make sure that you're giving notice to the subcontractor, to the subcontractor's insurance, as well as your own insurance carriers, just to make sure that you've covered all the bases.
That's very important. And I think that as you examine construction defect claims, it becomes really type of material where you have to master a lot of different things. There's contractual information you have to matter. There's subject matter, because these are complicated accidents. How do you make sure that you've got all of the technical expertise that you need in order to understand this, Ken? Let's keep it with you for a sec.
Well, that's a great question, Tom, and I think it's critically important for the practitioner to make sure that they're up to speed on both the design aspect of the project and as well as the means and methods of the project. You have to, as we said before, meet with your client and understand their work. That's critical. I had a case recently involving a pile driver who was building a 7-story building in the southern tier of New York. I knew nothing about pile driving, but I went out and I met him, and I saw his machines, and he sent me videos of what it is that his work looks like and helped me understand that process. But then along with that, another important aspect of that case was the type of ground or dirt or earth that the piles were being driven into. So I had to retain a geotechnical engineer who helped me understand how the engineering aspect of pile driving worked, and whether or not for the conditions on that particular site, the engineering specifications were applicable to that type of project. Turns out they weren't, and that was a big problem.
That's a huge opening for me to go right into Scott with. So Scott, tell me, extremely important to retain experts early in various different types of specialties. So as Ken says, you can know the whole lay of the land. Is that one of the things that goes top of the list when you're defending a construction defect claim?
Absolute top. Ken is right. I mean, we are experts in what we do in the law. We're experts in understanding the codes that are applicable, etc. But we're not experts in the construction itself. We learn about the construction as we go along. We understand it from our client, yes, but the experts are invaluable. And I am of the mindset that in each case, every aspect that you don't understand or that comes into question, you have the correct and proper expert for. And the selection of the expert is extremely important. Many times I go to the client and ask them, who do they respect in the industry? Who do they think would be a good expert to opine on their work and what they did? And most times I find who they recommend tend to be people that I can trust and I can use as experts on the construction defect. So as Ken said, piling, do I know that? No. Would I learn that? Of course. Would my client be able to show me certain things? Yes. But the expert is, quote unquote, a little bit more objective and may show you some of the things that were done right or not done right or could have been done differently. So you're prepared. And that also goes to one other aspect. Before you do depositions, unlike a liability in a bodily injury case, I would say, you might get your experts, medical experts, after the deposition of the plaintiff. That's not the case in construction litigation. You get your experts before depositions take place. You get your experts early on, so you know where to go with the case and how to question all the subcontractors or general contractor when their deposition time takes place.
Thanks, Scott. That's a terrific answer. Gives us a lot of insight into how one should successfully defend some of these claims. And let me turn back to Ken for a second, because we've touched on this a little bit, but I know from being involved tangentially in some of the work that Scott does and Ken does, that you mentioned inspections. How important are inspections? Is there just one inspection in these kinds of cases, multiple inspections, ongoing inspections? Ken, tell us a little bit about the purpose and the strategy for inspections.
Well, in my experience, you can never have enough inspections, quite honestly. But it's important to get there as soon as possible, because you want to document everything that's going on. You need your expert to point out the issues to you. You need your client to point out your work to you, but you need a darn good photographer there who's taking pictures of everything and documenting and showing on film or digitally exactly what the problems are. If you can't do that, you're behind the 8 ball right from the start. But then as the theories of the case develop, and this is, what you may initially see may not turn out to be exactly what the problem is. And that happened in another case that I recently had. Things changed as the case developed, and what the plaintiff was claiming was going on the very day that it happened was not quite the same thing that they were complaining about after things started being taken apart and looked at, and all of the engineers had an opportunity to get back in there and take a look and say, oh, well, all right, now we see what that is. So, and now we understand why that happened. So I would generally say that, you want to get one as soon as possible, but you might want to keep in mind that once the case has developed and there's an understanding as to what the real aspects of the defect is, then you're probably going to want another look at things. It may not always be possible, as we talked about previously. There's life and limb involved. So it may well be that within a very short period of time, less than a month, the whole situation is reconstructed so that people can get on with their lives. But you do the best that you can, and you document and you record everything that you possibly can. A good photographer is your best friend.
Great insight, Ken. Thank you so much. Let me turn it back now to Scott for a second, to something that I think is near and dear to his heart. And that's the question of, in these cases, there's a lot of parties and there's a lot of documents. So how do you maintain and how do you compile and how do you organize and make sure that you have all of the documents and materials that you need, both internally and both externally, so that you can respond, or you can respond to document requests, or you can prepare witnesses for depositions, or you can prepare affirmative litigation to help your client perhaps find someone else who might be at fault. Tell us a little bit about the challenges and the things that you need to do to make sure that the document retention is a friend and not a foe.
Yes. Well, it can be a foe, but we try to ensure here at PMT that it's a friend. And there are two different types or situations. One is if the documents are electronic, that's poses its own situation, but at the same time, it usually requires an outside ESI company to take those documents and put them all in storage, and so that they're retrievable and they're researchable. However, there are, and we still have them, cases where documents are the paper and their boxes. And we have one particular case where, and I know Tom is referring to it obliquely, but it's got at least 165 banker's box worth of documents. And how do you get a handle on that? Well, here at our firm, we have actually the capabilities to scan it and make it searchable, because making it searchable is the most important aspect, because you could put all those documents in a system, but if you can't look to find a particular subcontractor, say you're trying to find ABC subcontracting and all the documents that apply to ABC, then the scanning and having it all in one file has no value to you. You have to be able to pinpoint the types of documents you're looking for, the particular client or the particular subcontractor or contractor. Now, in some of our cases, we're the GC, so we hold the contracts and we get discovery from every single subcontractor. And the amount of documents is, you know, 1 million pages or more. So the searchability is the most important aspect, in the sense that if you are ready for a deposition, you don't want to have to go through and sift through all documents that you have. You have to only sift through those documents that apply to that subcontractor. Or if you're looking to bring a motion on the contracts themselves, then you only want to find all the subcontracts that are in place. So making them searchable and putting them in folders so that you have electronically in folders, so that you have all the documents of a particular subcontractor in one place, all the motions in one place. Unless you have a well-organized file, it's impossible to defend, or, as you might do if you're a GC or an owner, prosecute third-party actions against subcontractors. So the document retention and the document filing are paramount to handling the case properly.
That's terrific, Ken. Excuse me, that's terrific, Scott. I love your insight and I love your ability to give us concisely how important it is. Let me turn to Ken and ask him, Ken, you have the same impressions and the same understanding, and you've had the same kinds of things happen with your cases over the years with document retention?
Yeah, absolutely. I mean, you know, I think both Scott and I have been doing this long enough to remember back in the day when you received things via fax, or, you know, if you got discovery responses, they may have come, you know, in a banker's box full of documents, and you had to have a paralegal go through them and organize them all for yourself. Fortunately, with today's technology, there are electronic file transfer programs. You can use OneDrive. There's any number of share file type programs where you can transfer documents. And then once you receive them electronically, you can process them through various different programs. PDF is not it's a good format, but using Adobe is not quite useful enough to be able to do that. But there are offshoots of Adobe type programs that help you organize and put things together. I had a case that I just resolved a little while ago where we had a daily diary of one of the inspectors on the project, and it was over 2,500 pages long. And it was critical because what he saw, what he examined, what he approved was absolutely critical to the case. And we had to go through that. And you know, 2,500 pages is not a million, as Scott said, but it's still fairly daunting. you're kind of cross-eyed by the time you're done with it. So using electronic medium is really the way to go. And we're lucky to be out of the circumstance for the most part, where we're looking at 120 some boxes of documents. I don't envy you, Scott.
Thanks, thanks, Ken. And I'm sure, if Scott could pass this on, I think he would like to pass it on. But
Yes.
sometimes, like I say, when you have lemons, you have to make lemonade. And this may be one of those, we need a couple of pitchers to make all that lemonade that we're going to make. But it sounds like to be a successful attorney handling construction defect, you have to be able to master technical materials. You have to be able to be organized and master the organization, both of the documents and of the externals. And you also have to have a wide vista in terms of where does this fit into the general larger picture. Let me turn to Scott and ask you a question that probably is one of the critical elements here in construction defect claims. What are the damages? What kinds of damages are there? Are there economic damages, economic loss? What kinds of damages can they be, and how significant can they be?
Well, they can be extremely significant. And the types of damages, there are two types. There's types that are just the work itself and whether or not the work itself was defective and has to be repaired. That's an economic loss. But then many times, because of the defect, third-party damages are caused. For example, if a curtain wall goes up and a curtain wall on the exterior of the building leaks, well, the curtain wall itself has to be repaired, obviously, but the damage that the leaks cause to the individual units or apartments is third-party damage, and that can be extremely extensive. It can be that the building itself cannot be occupied, or that each one of those tenants must leave the building and be put up in alternative housing for the time being. And that can be a very expensive proposition when you're talking about luxury apartment buildings or condos in New York City. To put someone up in the type of residence that they are used to, and you have to put them up in something similar to what they're accustomed to, is a very expensive proposition. The damage itself is very expensive. We've had other situations where during excavation, problems were caused. The problems with the excavation, sometimes, of course, the excavation itself might have to be redone, but it can cause damage to the neighboring adjacent buildings, severe damage to those buildings. And each one of those tenants might be displaced for some period of time. The building itself might have to be renovated or the defects corrected, because we live so close to each other in New York. So what you do and the construction you do on one property always affects other properties. So the damage can be in the millions, in the multi-millions on some of these situations and some of these claims for construction defect.
Thanks, Scott. And I want to ask Ken, from his experience litigating construction defect cases and claims, have you seen the same scope and the same range of defects in the matters that you've handled as Scott has?
Absolutely. And there's, in some ways, there's a clear distinction, even though any given case may involve both aspects. As Scott says, I in fact have a curtain wall case in downtown Buffalo, and there is the aspect of my client's work that had to be replaced, but there was damage to the interior of the building, which had to be repaired and added substantially to the cost of the entire repair. Our work was not that big a part of it, but what it caused was a bigger problem. So those are very, very important aspects of the case for insurance reasons, if for no other reason. But we experience them all.
That's a very, very insightful answer, Ken. And I want to thank, we're running out of time here. And I wanted to wrap it up and thank both Ken, and I wanted to thank Scott for this most incisive podcast on construction defect claims. If you didn't know the area and you listen to this podcast, you will have an excellent understanding because you've been treated to a very, very high intensity synopsis of the area by two very, very experienced and expert attorneys from Pillinger Miller Tarallo. So I'd like to thank Scott Miller for his time and for his expertise today. And I'd also like to thank Ken because we are very, very fortunate at our firm that we are able to cover construction defect litigation from upstate, downstate, east and west. The whole state we've got covered with expert attorneys in construction defect like Scott and Ken. So I want to thank both of you guys for your time today and for giving us the insight and the benefit of all your years of experience. Thank you so much.
Thank you, Tom.
Thank you, Tom. Appreciate the opportunity.
Yes.
Thank you.
Always a pleasure.
Thanks, Ken.